Hello and welcome, Employment Law Show. Once again, good to have you along today for this 30 minutes of knowledge and education all about employment law. John Scholes here. Beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in this country of Canada of ours, from coast to coast to coast. You can check it out, and you can also reach out anytime to Lior and his team. You want to phone call 1-855-821-5900, help@employmentlawyer.ca, and a website that is free. It's anonymous. We'll refer to it all the way through the show, called pocketemploymentlawyer.ca. More details on that as we go through this 30 minutes. Lior, busy show today. Termination for cause, true or false? That is going to be the main topic in just a little bit. And I like this one because I have the notes in front of me. Usually, in years past, you make me do this live on TV or radio, which was never nice. But now you can't do that because I have the notes as well. So I'll be asking the questions and you can answer them for everybody out there. So I'm kind of pleased by that. But that's coming here in just a bit. We always start with the case of the day, the week that was, pal. What do you got going on this week?
Always looking for the easy way out, John. Unbelievable. We'll let you get away with it this one time. Well, thank you very much, Johnny, and welcome everyone to our show once again to talk about employment law, workplace rights, and hopefully make sure that when you turn off the TV or change the channel in 30 minutes, you know a lot more than you did coming in, that you know about your legal rights. You know what to do if you're facing a workplace problem or dilemma. You know how to deal with an ultimatum or a problem. You know what to do if you lost your job, if you're bullied, if your job has changed. We talk about those things every single time on the show, and we do that because we want to provide solutions. I've said this a million times, but it bears repeating. The law in this country, employment law, is excellent. It's good. We have some of the best employment laws in the world in this country, but people don't know what those are. People assume wrong things about the law. Well, the law can't help you if you don't know what it is, if you don't give it an opportunity. Well, by watching this show, you'll know what the law is. You'll know what to do to solve your workplace problems. That is exactly what we're all about on this show. So I'm glad you're joining us. And of course, always, this is something you have to know. If you want to connect with me so I can actually help you, or my team can help you to solve your workplace issue, to help further your understanding of the law, we'll give you that contact information throughout the show so we can have a chat, so we can have that discussion off air. But with that said, let's talk about a situation that I dealt with over the past week. And this one I like because it intersects between probationary employees and the severance for short service employees. Oh. So I spoke with a gentleman that had worked 2 days shy of 3 months with his employer. He worked as a supervisor in a manufacturing facility, and he was let go shortly before his 90 days. The employer said, listen, it's just not a right fit. We just think we need someone with different experience and different skills, nothing personal. So they decided to let him go. They offered him 2 weeks' pay. Now, his initial reaction was, well, that's pretty good, right? I've only been there for less than 3 months. I'm on probation, so getting 2 weeks' pay is really, really good. Well, luckily, he listened to his significant other who told him to call me, and he did. So here's the thing, John. The first thing to remember is that probation only exists if you sign an employment agreement that specifically says you are on probation. He didn't. He did not sign an employment agreement saying on probation. Because of that, he gets severance even though he's been there for less than 3 months. Now, the question then becomes, is 2 weeks enough for him? Not even close. I assessed him as being owed 3 to 4 months of severance. Months. Now, he's been there for less than 3 months. He's going to be owed no less than 3 months severance. And the reason for that, you know this, hopefully our regular viewers know, short service employees are treated disproportionately better than long service employees. Now, he thought 2 weeks, great, been there for such a short period of time. In fact, he's owed more than 3 months pay. And I'm going to help him get that. But a reminder for everyone. Number one, you're not on probation unless you sign an agreement saying that you are. And number two, equally as important, more important maybe even, if you're a short service employee, 2 months, 6 months, 1 year, it doesn't matter. You are owed still a significant amount of severance that's going to be measured in months, not in days, not in weeks. So if you lost your job, I don't care if you've been there for a short period of time, you have to get that advice. You have to make sure you get what you're owed. Chances are that your employer is going to offer you a lot less than what you're legally owed. That's where I come in. So feel free to reach out in that situation.
Yeah, you've often said that on the radio show as well, disproportionately larger amount of severance for short service employees. We get that, but why is that so?
Well, we have to think back as to what is the purpose of severance. The purpose of severance is to help the employee while they don't have other income, to help them to transition to another job. Well, just because you work somewhere for a short period of time doesn't mean you're gonna find a job very quickly. In fact, it may take you longer to find a job because you'll have to explain to the new employer why you worked such a short time with the previous company. So because of that, severance is still significant. You're still going to take a while to find a job, and that's what that severance is for. It's like an insurance policy to help take you and carry you to that next job.
You know, you did mention that this is the probation period of 90 days, 3 months, is a creature of an employment agreement. That's fine. So a lot of people would assume, I thought every job came with a probation period of 3 months, and maybe a lot of employers are thinking that as well. Is this something that you would, from the employer standpoint, instruct them always to have on an employment agreement, and from the employee standpoint, try to avoid that if you can, or is that not a big deal, 3 months?
Well, listen, if you are an employee and you have a choice to be on probation or not to be on probation, of course you're going to choose not to be on probation. That's always better, right? You can't argue with that. So if you did not sign something putting you on probation, that's great. Certainly don't ask for it. Now, from an employer standpoint, the opposite is true. Yes, you would want to have a period of time to assess someone and to determine whether they're a good fit. That period usually can't be more than 90 days. But to do that, you have to have a proper employment agreement that says that. So depending on your perspective, employer and employee, there's your answer.
Can it be extended if I'm an employer and I'm thinking, okay, 3 months is good, 90 days, I want to double that to 6 months. Can I do that?
You can't. Well, practically speaking, you can't, because the period of time during which you can let someone go without severance is 90 days only. And of course, only if that's what the employment agreement says. After 90 days, doesn't matter what the agreement says, you would have to pay severance anyway. So there's really no point to have a period of probation that's longer than 90 days.
Again, reaching out to Lior, if this is a question you have moving forward, 1-855-821-5900, 1-855-821-5900. I did mention our radio show, employmentlawyer.ca. There's a media tab on that website, right? You can search for a station across the country that carries that, our weekly show, and nightly in some markets as well. It's an hour long or a half hour long. Great show. You want to catch up on that, you can do so on the website. We get a lot of phone calls every week, Lior. We're always talking to people about their jobs, their rights, what they do and don't know. We like to cherry pick some of those phone calls, play them back here, and just talk about some of the matters. We'll get to our first phone call for the day right now, pal.
I've been working with a company for about 15 years now in the position of office manager. Just about prepared to walk away because of what I consider to be some workplace harassment and bullying and unfavorable conditions in the workplace. I feel that I can't continue on if I do have any rights.
Good call.
It's a good call, and it's a common call. You know, when it comes to workplace harassment and bullying, etc., those issues, unfortunately, are common, and they're things that I deal with all the time. So let's start with this idea that every employee, I don't care who you are, you have the right to work in a harassment-free work environment. You absolutely do. It's not just the right thing to do, it's the legal thing that an employer has to do to maintain that harassment-free workplace. That means that an employer has to, of course, deal with harassment issues, investigate and resolve them. So the first thing I would say to her is give your employer the opportunity to resolve this issue. Talk to someone in the company, whether it's the owner, whether it's HR, whether it's someone else that's the appropriate person. Tell them what's happening in writing. You always want that record, and then give them that opportunity to resolve it. Now, if they don't resolve it, then we can deal with it externally. You can get out of there with compensation. Workplace harassment, or being subject to workplace harassment, can result in a constructive dismissal. In other words, if you leave because of the harassment, the law would consider that potentially as a termination, meaning you are owed severance even though you're the one that chose to leave the company. The question then, of course, becomes, well, how much severance? Well, let's take this particular person's information. Let's plug that into our handy tool, the pocketemploymentlawyer.ca, our severance calculator you can find there on the pocketemploymentlawyer.ca website, and let's see how much she's actually owed by way of severance. So we know she's an office manager that's been there for 15 years. We can see that her age is approximately 50 years old. If she leaves, you see at the bottom of the screen, she is owed anywhere from 16 to 18 months of severance. 16 to 18 months of severance. That's what's at stake for her. So yes, that the law does provide for options and rights and things that she can do if she's harassed and bullied. If you're not sure what to do in that situation, or how much you're owed, or how to deal with that workplace harassment, first thing you do is you give me a call.
For those watching and thinking, you know, Lior, I get that, the harassment, that I have that in my workplace. It sounds very similar to my story, except I don't work for a big corporation with a robust HR department. In fact, it's a 2-3 person shop, and the boss is the one doing the harassing. I can't report to him. He's not going to admit to it, or she's not going to admit to it. What do I do?
Yeah, who do you report to then? Then in that situation, there's no one to report to. So we need to look at constructive dismissal to get you out of there. And in other words, deal with it externally. The key, though, is to be able to prove the harassment. It's very important to remember that the person that's harassing you is not going to admit it. They're going to deny it. They're going to say you made it up. So we need to have a way to prove what happened. So is there a recording? Is there emails? Is there a journal or a note that you wrote contemporaneously? Did you send someone an email confirming what happened? All those are ways to document and prove the harassment. It is important that you prove it. If you can prove it, then absolutely that could be a constructive dismissal. And yes, you could be owed as much as 24 months' pay.
Again, don't feel bashful to reach out anytime just to have a conversation with Lior, a member of his firm. They're great. 1-855-821-5900, help@employmentlawyer.ca. Another place for you to ask questions anytime. Terminationquestions.com. It's free. It's anonymous. And again, we'd like to read them out on the show because it helps educate you and all of us about employment rights. This one, first one for the show today, Lior, is from Elaine. Says, I was employed at my company for almost 6 months before I was fired with no cause or reason. I didn't receive a record of employment and was offered just a week's worth of pay. I know I was only employed for a short period, but am I entitled to anything else?
So this dovetails really well with what we were talking about at the beginning of the show, short service employees. So, you know, Elaine only worked there for 6 months. But keep in mind, even after 6 months, she's going to have significant entitlements. Now, I don't know exactly what her job was, right, and her age. So I can't assess it exactly, but I can tell you it's going to be somewhere north of 2 months' pay. It could be as much as 6 months' pay. If she was so older and had a senior position, it could easily be 6 months. It could even be more than 6 months' pay. So the 1 week's pay that she was offered is nothing. It's not even on, and it's not close. She's owed much, much more than that. Now, with respect to a record of employment, obviously the employer has to file it. Clearly, this employer doesn't know what they're doing. We can deal with that. One email or letter from me, you get the record of employment. So she needs to call me. She has been wrongfully dismissed. She's owed more than 1 week's pay. And again, yet another important reminder for everyone that short service employees, 6 months is short service. Her severance is measured in months, not days, not weeks.
Short break, termination for cause, true or false. This is going to be a fun home game, so stick around for that. In the meantime, the phone number, 1-855-821-5900. Email help@employmentlawyer.ca. And again, terminationquestions.com to reach out anytime as well. We'll continue. More Employment Law Show is coming right up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. Good to have you along. John Scholes, Lior Samfiru, a co-founding partner of Samfiru, Tumarkin, LLP. Feel free to reach out anytime by phone or email or otherwise. The most positively reviewed law firm in the country. 1-855-821-5900. help@employmentlawyer.ca. All right, Lior, let's get into this. You're in the hot seat. You know all the answers, so it's not really that. It's lukewarm. Termination for cause, true or false questions. Let's get into this. Number one, termination for cause is considered the capital punishment of employment law. I think that might be your quote. Maybe.
Yes, it is a quote that I very often use, and it's because, well, it's true, okay? Termination for cause, the easiest way, the best way to look at a termination for cause, it's the capital punishment. It's the death penalty of the employment relationship. And the reason why that analogy makes sense is just like capital punishment, it's reserved only for the worst offenders. So what does a termination for cause mean? A termination for cause means you did something so bad, so terrible, that you're deserving of the worst punishment, which is, of course, a termination for cause. In a termination for cause, if in fact your employer can prove that you were deserving of the worst penalty, you can be let go without any compensation. That's why it's such a bad thing. Now, the good news, of course, is that in many, many cases, employers get this wrong. But I want you always to remember, it's not a question of whether or not you did something wrong. It's a question of, did you do something that's so bad that it's just impossible to continue to employ you, and now you're deserving of the worst punishment that an employer can give you, i.e. a termination for cause.
Termination for cause, true or false? Again, we underline the word cause, especially with number two. True or false, Lior, employers can fire an employee for cause for a simple mistake or error.
So I touched on that. That, of course, is false. Yes, you can be let go for a simple mistake. You can be let go even if you've made no mistake. But that's not a termination for cause. That's a termination without cause, meaning you are owed your full severance. The distinction, the difference between a termination for cause and a termination without cause is severance. With a for cause termination, if it's done properly, you don't get severance. With a without cause termination, you get your full severance up to 24 months pay. So no, you cannot be deprived severance. You cannot be terminated for cause if you made a mistake, just a mistake, or if you've done something wrong, if your performance is not up to par. It's very difficult. It's the capital punishment, as I said, to terminate for cause. The employer would have to show much, much more than that. And if your employer says they're terminating you for cause when what you've done is not that bad, well, that's exactly what a wrongful dismissal is.
Termination for cause, true or false? Lior, next one. True or false? Employers often implement a performance improvement plan to eventually terminate an employee for cause.
So employers know often that they have to work hard to terminate for cause. They have to build their case. So yeah, that statement is true, because what a lot of employers may do is to build to that termination for cause, they may put you on a performance improvement plan and use that kind of as a building block to get to the point of terminating for cause. Look, this person had a bad performance. We tried to fix their performance. We even put them on a performance improvement plan. Nothing worked. Nothing was successful. What choice do we have? We have to terminate for cause. So whenever you get a negative or you're put on a performance improvement plan, be careful, because it's often that the employer is trying to build a case for cause. If you disagree with the performance improvement plan, if you disagree with the facts or the allegations or with the comments on your performance, say so in writing. Don't just accept it without saying anything. If you say so in writing, you're going to make it much harder for the company to let you go for cause. You should not ignore a performance improvement plan.
You know, it's interesting. You talk about, building up a case in relation to this. I mean, is one performance improvement plan enough to be fired for cause, or if you've done 2 or 3 things wrong? I mean, how much of a backlog does an employer have to build up before they can, as you say, pull the trigger for cause?
Every situation is different, and it's hard to kind of have an exact roadmap to a termination for cause. Generally speaking, I would expect to see 3 things, if you will. before an employer can terminate for cause, either 3 warnings or on a performance improvement plan and 2 warnings, or you know what I mean, something where the employer can say, I gave you 3 chances, kind of 3 strikes you're out type of a thing. Now, in some cases, the employer is going to need more than 3. In other cases, they won't need as many as 3. But as a good rule of thumb, if this is kind of a one-off thing, a one-incident situation, it's almost never going to be cause.
Termination for cause, true or false? Number 4, Lior, true or false? It is simple and easy for employers to prove a termination for cause.
So I won't even talk long on that because we talked about that. That is, of course, completely false. It's very, very difficult to terminate for cause. It's a high standard. The employer has to prove, number 1, that you did what they said that you did, and number 2, that it's bad enough to be cause, that there's no other remedy available. In most cases, John, employers don't do that. They don't work hard enough to build up that case, and if they don't, they can't prove cause, meaning they still owe the person their full severance.
And final one is this, true or false, Lior? Employees that are terminated for cause are likely still owed severance pay. How about that?
So if your employer did everything right, they build up their case, you did something that wasn't good, and they gave you warning and a warning and a warning, and eventually they terminate for cause, even in those situations, there are many instances where you can still get severance. Maybe not your full severance, at least some of your severance. So very good reason. Whether you're let go and you have clean hands or you don't have clean hands, you got to get some advice. You'd be surprised how many times people believe and assume that because they did something wrong, that's it, they're done. They don't get any severance, where in fact they could be owed months and months pay, even if they're not good employees necessarily, even if they did something wrong. So what do? You call me, we discuss it, and we assess how much you're owed.
And in that regard, never be bashful. 1-855-821-5900. help@employmentlawyer.ca and terminationquestions.com, by the way, to ask any other questions during or after the show. And employmentlawyer.ca, mention that at the top. That is the firm website, and on there is a media tab, a chance for you to find a radio station where we had our, decade-long radio show going on across the country. You can reach out, listen, and call into those shows depending on where you are. And sometimes we'll play your call back and talk about it here. In fact, phone call number 2 for the day, Lior, is coming up right now.
Calling on behalf of my wife. She recently received termination notice this week. She is currently on mat leave, and the company is going through some restructuring. How much notice is the company supposed to give her before serving her termination? What should she be entitled to in severance? And can they actually do that? She's on mat leave. Can they serve notice? Are there any special conditions on that?
Don't mess with mama.
You don't mess with mama. There's a lot of issues with terminating someone that's on a parental leave. There's employment standards violation, human rights issues, other issues as well, wrongful dismissal. So you have to be very careful. The only time an employer can terminate an employee that's on a parental leave is if there's just no possibility of bringing them back. That job is gone. It doesn't exist anymore. We shut down the department. Well, what can we do? There's no department, so there's no job. It's very difficult. It's not enough to show, well, we hired someone else. Can't do that. It's not enough to show that we're restructuring. Again, not good enough. Now, here's the thing. Let's give this company the benefit of the doubt. Let's assume that they shut down the department, so they don't have a job. Well, if the person is still on a parental leave, how do they know now that they're not going to have a job for her when she's ready to come back to work? If she's not coming back for another, 10 months, let's say, maybe at that point, they're desperate for someone in her role. So that employer, by jumping the gun, by assuming today that we know that months from now we're not going to have a job for you, but that employer breaches the Employment Standards Act. It's illegal. They could have done is they could have said, just so you know, as of right now, we don't have a job for you, but we're going to assess that when you're ready to come back to work, and we will see what happens then. So by not doing that, they're in breach of statutes. It's a wrongful dismissal. So there's a lot there to discuss, and that's something we need to discuss in person. But remember the rule. It's very, very difficult. And in most situations, it's illegal to terminate someone, a father or mother, that's off on a parental leave.
Yeah, a little bit of a distinction there, right, between a parental leave and, say, a disability leave, where you can be brought back to a different job, when you're ready to come back, versus a parental leave, where they can hire someone to fill your gig while you're gone for up to a year and a half, at least in Ontario, maybe some other provinces, but you've got to come back to the same job. That's different, correct?
Correct, yes. With a parental leave, your job is essentially guaranteed. Your job, your pay, whatever you were doing before. With a disability leave, it's not the same level of guaranteed. What's guaranteed is that your employer has to try to bring you back if at all possible. So not quite the same level of guarantee. But even with the disability leave, if ultimately you lose your job because there's no job for you when you're ready to come back, you're still going to be owed your full severance, again, as much as 24 months pay.
Short break and right back at it. In the meantime, phone number 1-855-821-5900 and help@employmentlawyer.ca. This is the Employment Law Show. A few more minutes are coming up, so stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes and Lior Samfiru, of course. 1-855-821-5900 to reach out anytime, and employmentlawyer.ca to find a radio station across the country that carries our radio show for the last decade. I think we got time for at least one more phone call from our radio show, so we'll get to that right now, Lior.
If an employer gives you an employment letter and puts various aspects in there, such as probation period will now be 120 days, but yet employment standard says 90 days, can his employment letter supersede the employment standard?
So we touched on this, John, right at the beginning of the show, extending probationary period. There really is no meaning to a probationary period that's longer than 90 days, because the period of time during which an employer can let someone go without any severance, that period cannot be longer than the first 90 days of employment. And of course, only if that's what the employment agreement says. So extending it to 120 days means nothing. Even if you sign something, it doesn't do anything. So there's no point for an employer to ever do that, John.
Let's get to a quick terminationquestions.com with our last couple minutes, pal. This one from Francis says, I worked as an aviation manager for almost 30 years. I'm almost 60 and not a union member. My position was recently eliminated, but I was told I could apply for another job within the company. The new job is an entry-level position and not in the same field. The prospect of training is overwhelming. What should I do?
Well, because it's such a different job, she does not have the obligation to accept it. She doesn't have to accept a demotion of a vastly different job. This is what we call a constructive dismissal. She can treat that as a termination. Same with you at home if you're in that situation. So let's go to pocketemploymentlawyer.ca quickly. Let's use our severance calculator, and let's see how much severance is going to be owed after those 30 years. Again, even though she's not actually being terminated, it's a constructive dismissal. So we know, John, that she's an aviation manager that's been there for 30 years, 59 years of age. She hasn't been offered severance because it's a constructive dismissal, but you see she's owed as much as 24 months' pay. 24 months' pay. That's how easy it is to use, by the way, at pocketemploymentlawyer.ca. You can do that as well, free, anonymous, so check it out.
Yeah, that one's one of those classic 24-monthers, 60 years of age and 30 years of service. That's absolutely a no-brainer right there. But she mentioned in there as well being a non-union member. Give me details just briefly if people don't know why that's important.
So, John, everything we talk about on the show and our radio shows really only applies to non-union employees. Union employees have different rights, and those rights can only be enforced by the union. You can't hire a lawyer. You can't give up the union rights. It has to be the union. So if you're ever in a workplace situation where your union rights are being compromised or you have issues, you have to take that to the union, and only the union can help.
And with that, we are just about out of time. Appreciate you so much. If you've had your phone call played on air, keep giving those on our radio show. We'd love to have them. EmploymentLawyer.ca to find a station. The number 1-855-821-5900 and the email help@employmentlawyer.ca. And then finally, pocketemploymentlawyer.ca as well. We'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.